We want to now bring in our senior reporter, Catherine Falders, and ABC News legal contributor, Kim Whaley, for more on this. And Catherine, starting with you, what here is the practical impact of a protective order? What could it be in this case, considering that Trump is very actively campaigning for president?
Well, you saw Trump's campaign team respond to this protective order, this filing, and they essentially said that this is limiting his free speech, for example. But it's important to point out that these protective orders are standard moves by prosecutors. There's a protective order in place in the Manhattan case. There's a protective order in place in Jack Smith's investigation in the Mar-a-Lago documents, for example. So it's not rare at all that they would seek a protective order before providing discovery to the defendant. And special counsel Jack Smith, of course, has made the case that this needs to be in place because Trump has a tendency to attack witnesses, to attack judges, to attack lawyers, for example, involved in this case. So the reality of this is that there is a deadline. The deadline for Trump's team to respond is 5 p.m. today, as Pierre noted. And this is after they tried to delay this deadline, for example. The judge over the weekend denied that and said the Trump legal team does have to respond to Jack Smith, again, by close of business today. So we'll see the arguments that they make in their filing.
All right, Catherine, and Kim, to you, as you just heard, former President Trump's attorney is saying, this protective order essentially could be a violation of the free press. What do you make of that argument, and what will the judge take into account when considering this protective order?
Well, Kana, there's a lot of distortion and misinformation flying around lately about the First Amendment. The First Amendment doesn't protect any kind of speech at all times. And here, to make the argument that there's a free press right, that right actually belongs to the press, not to Donald Trump. So if there were a point where a member of the press or a news outlet decided that they wanted access to information, they would seek the court's authority or ruling from the court allowing that to come out. Essentially, the First Amendment test for this looks to whether there's a compelling interest on the government to keep this stuff quiet and whether that's narrowly tailored. So here, as Catherine indicated, the compelling interest is safety of witnesses. I mean, that's the high water mark, in addition to just maybe prejudicing the jury by discussing the evidence prior to the trial. The narrowly tailored part, I think, is also there, because if you read the proposed order, what Jack Smith is suggesting that if Donald Trump wants to make things public, first of all, these documents can only be looked at in the presence of his lawyers. And if they want to make something public, they just have to get the judge's okay in advance. So it seems to me that that test is satisfied, and this is more political blustering than actual serious legal arguments.
And Kim, what about Trump's attorney saying that he plans to file a motion to dismiss this case entirely on grounds that Trump's immune to being prosecuted for anything he did while in office?
I have been anticipating this motion for quite a while, and I think we'll probably see it in Mar-a-Lago as well, because part of the fact pattern, he was president of the United States. Now, he made this argument with respect to documents when he was president. This Supreme Court struck it down, and we all have to look back to, United States versus Nixon, where the Supreme Court held that tapes in the White House were not protected, and he's arguing something even broader, immunity. That I think is going to fail, but it will delay potentially the proceedings and maybe get him a trial date after the election.
All right, and the word delay, Catherine, we keep hearing that a lot. The judge pushing to get this trial date, though. What's the latest there?
Yeah, delay has been this tactic of the Trump legal team. The judge has given both sides of this 2 weeks to propose a trial date. So prosecutors need to propose a trial date by this Thursday. Trump's team needs to respond to that and propose a trial date by next Thursday. But you saw in court during that arraignment the first tests of this and their delay tactics, for example. So we'll see what the Trump legal team says. If they propose an indefinite trial date, as they did as it related to the Mar-a-Lago documents. Of course, the judge in that case didn't accept that. Or if they do issue some sort of proposal that seems to be more in line with the special counsel. I highly doubt that, but we'll see come 2 weeks from now.
All right, Catherine Falders and Kim Whaley, thank you both for your time this morning.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.